First thing I want to talk about is to make sure that we understand what this webinar is doing. We're looking at drafting. We're looking at drafting documentation. In particular, I'm looking at drafting documentation given the changes in the legislation that we've seen relating to building safety, with regard to ground rents, with regard to fire safety, and also the code of practice relating to new builds that we need to explore. So all of those things really are the purpose that we're going to be looking at today. But in particular, the consumer code for home builders, I think, is important in that we must make sure that what we're drafting is consistent with that code. So first things first then, today, let's talk about some drafting issues generally. What can we extract from what the courts are saying relating to drafting? I think the first thing is that we've got to be careful in that the courts these days are far more likely to give effect to wording that is used rather than attempting to determine what the party intended the wording to achieve. So the courts have sort of reverted back to an old literal type of approach. If that's the wording that's in the lease, that must be there for a particular reason. And as a court or a tribunal, we're not prepared to interpret it. So unless it's a nonsensical, unless we've got evidence of clear intention from the parties that this wasn't what was meant to be achieved, we will stick with the words that we've got. That means, as I say, and as usual, we've got to be careful with wording that we use. If we're using formula or calculations, put worked examples. If we're using terminology, that it's important that we provide definitions. If we're referring to technical documentation, be it the Building Safety Act, any of the fire safety legislation, the Consumer Code for home builders, the courts will always prescribe a technical meaning to technical wording. Therefore, it's important if we start talking about relevant persons and relevant buildings, as per the Building Safety Act, it's important that we understand and appreciate what that terminology actually means. And it might be necessary and indeed appropriate to give our own definition if the definition within the Act isn't sufficient for our purposes. How do the courts interpret contractual terms that I mentioned? They'll give effect to the wording that's used unless it's nonsensical and unless there's evidence of clear intent from both sets of parties that something else was meant. The courts have in the past interpreted documentation to give business efficacy to a document or to give effect to the intention of the parties, and they will do so, but only when the literal meaning generates an absurd result. On this point, there are two or three things that I think are worthy of discussion and worthy of mention. In interpreting a lease, the courts will look at contemporaneous documents that were entered into between the parties at the point that the lease was entered into. So there might be a contract, there might be heads of term, there might be agents' particulars, there might be marketing material that's produced by the landlord. It's important that our lease is consistent with that, or that at the very least we're aware of what that documentation has to say.